All right. So officially, good evening, everyone. Thank you for coming to our critical estate planning tips for those living with disabilities. My name is Emily Crosby. I use she, her pronouns, and I'm the lead coordinator of education and advocacy here at Motions. I'll give a quick audio description of myself before I introduce our presenters. I'm a white woman, 24 years old. I wear gold rimmed aviator glasses. I've got dirty blonde, now more brown auburn hair. I'm wearing a black sweater, and my background are my white closet doors, a little bit of my one red wall, and my tan walls behind that. So tonight, attorney Kim Fierro of Timothy Rice Estate and Elder Law Firm, as well as Ellen Nelvin of the executive director of Plan NJ, will be speaking with us tonight. So without further ado, I'll pass it off to them to introduce themselves.
Thank you so much. My name is Kim Fierro, and I am an attorney with the Timothy Rice Estate and Elder Law Firm. I'm going to get into I guess I can start with a little bit about what I do at the law firm, but I'll get into that more after Ellen has an opportunity to introduce herself before I start the presentation. I am a white female, 48 years old. I have shoulder length curly auburn hair. I'm wearing glasses and a white jacket, and behind me is a white closet door and my sort of green, light green. It almost doesn't look green in the picture, wall behind me.
Hi, and my name is Ellen Nalvin. I'm the executive director of Plan New Jersey, and I look forward to telling you more about Plan New Jersey. I am also a white woman with glasses and curly brown shoulder length hair, and I am in my my sunroom. So I've got wood on the ceiling and a lot of plants. That we enjoy, my husband and I enjoy taking care of. And we're looking forward to talking with you today.
Thank you so much. So if it pleases everyone, I'll begin the presentation. We're going to talk a little bit about legal aspects of some of these topics. Ellen will also be covering some of these topics, but from a little bit of a different perspective. And so we thought maybe it would be a good idea to start with, explaining the legal definitions, what these words mean. I'll give you a little bit of background, and then, Ellen will kind of take it from there and put a little different spin on it for everybody here. I'm going to just go to, if you cannot see my screen, let us know, put it in the chat. We'll see what we can do to help you. This next slide tells you a little bit about me. I've been practicing law for 20 years. I've been living in New Jersey for most of that time. Prior to that, I lived in New York. And I've had a bit of a different background. I think, say for the most part, I don't think I've had many jobs in the last 20 years, but most of my legal career was with legal services, specifically Ocean Monmouth Legal Services, where we provided free legal representation to persons residing in Ocean and Monmouth County who were low income, disabled, or were seniors. I did that for 12 years, then went into private practice where I started learning a lot about estate planning and elder law, among other areas of law. I really enjoyed estate planning and elder law, which is why I decided to seek out a job where I can really focus on those areas. And lucky for me, Tim Rice was looking to hire an attorney at that time, and I was happy to be able to start working with him. And I've been with the Timothy Rice Estate and Elder Law Firm for the last almost 3 years. We handle many different areas of the law. We do provide estate planning information, which would include wills, power of attorney, advanced medical directives. We also do provide assistance with estate administration and estate litigation. We help with Medicaid applications and other elder law issues. as well as some trust planning and disability planning. So that's what we're going to focus on today. And I would like to first kind of talk about, I think there's a lot of confusion regarding when you need a power of attorney, when you need a conservatorship, when you need a guardianship. A lot of people have been talking about Britney Spears recently and her conservatorship in California. I would think that's probably where it is, but every state is different. Every state's laws are different. So we have to look at it from the perspective of the state of New Jersey. And I'm going to tell you a little bit about these different estate planning tools and what the differences are and when you may need one over another. So we'll talk about the power of attorney first. And the power of attorney is a document where an individual appoints someone to be their agent. Another word for that is attorney in fact, but most people use the term agent. And what does that agent do for you? That agent can act on your behalf, and you can grant that agent many different types of power, whether it be the ability to do banking for you, the ability to review and execute legal contracts, or sell real estate. Your power of attorney can be as broad or as narrow as you want it to be, because it really just depends on what type of power you want to grant to your agent. It is important. It's a very important document because a well-drafted power of attorney can continue even if you become disabled or incapacitated. So that means you're granting a person the ability to act on your behalf, and that would continue even upon disability. It is revocable. Court involvement is not necessary. It can be revoked at any time. And the most important thing is, in order to execute a power of attorney or sign a power of attorney, you have to have capacity. So and I'll talk a little bit more about a guardianship later, but if someone was unable to understand the nature of what a power of attorney is and does due to a disability or illness that limits their capacity, then unfortunately they would not be able to sign a power of attorney. So this is a very important document. I'm actually going to flip to my next slide. And so the power of attorney document really talks more about financial type matters. This is often very confused with a medical directive. A medical directive focuses on medical decisions and what type of care you want if you are unable to communicate what you want to your doctor or to a hospital. So for example, if there was an unfortunate accident and I was hospitalized and I was unable to communicate to the doctor about what type of life-sustaining treatments I want or may not want, or for religious reasons, I may or may not want blood transfusions or things of that nature, my medical directive would give that instruction. Again, the medical directive can be as general or as specific as you want it to be, and we tailor our documents to the wishes and needs of our clients. You again have to have capacity in order to sign this medical directive, and you would also, much like the power of an attorney, appoint an agent who would act on your behalf. This is, again, similar to the power of attorney, is revocable. There's no court involvement, and you can, and what do I mean by revocable is you can change your mind if you no longer want this person to act as your agent. If you want to change the agent, or you want to revoke the power of attorney altogether, or revoke the medical directive altogether, you have the right to do that. It's very important, and at this slide we kind of point out, I don't remember if any of you can recall, it was many years ago, the case of Terri Schiavo, where there was a lot of fighting and disputing amongst the family regarding her end of life care. And I think that the preparation of a clear and concise medical directive would eliminate a lot of that infighting between families, and also give you the assurance that your end of life treatment or end of life care will be respected by your family as well as followed by any medical professionals. Okay, I also, so forgive me, I do have an outline for myself because I want to just make sure that I cover all the topics and all the points. And one of the things on my list here is, is there a difference between a living will and a healthcare directive? Because I think you hear a lot of people refer to a directive as a living will or vice versa. A living will is more of an instructive directive, meaning you're explaining or expressing what you wish and desire as far as end of life care, but they don't necessarily appoint an agent in the event of incapacity. And so it's important that, again, you have a well-drafted medical directive that complies with New Jersey law, so there's no doubt that your medical wishes will be followed. So let's talk a little bit about then conservatorship, because as I had mentioned earlier, a lot of people are buzzing about conservatorship because there's a documentary out regarding Britney Spears and what she's been dealing with as far as her conservatorship. So I can't speak to the details of that, but I can certainly tell you a little bit more about conservatorship in New Jersey. So a conservatorship is more of a formal process. So unlike a power of attorney, which an attorney can draft, the principal, the person who wants the power of attorney drafted, just signs off on it. It has to be witnessed and notarized. This can all happen in an attorney's office very informally. So unlike a power of attorney, a conservatorship is a more formal process. You have to make application through the court, and the person who is seeking a conservator, also known as a conservatee, has to agree to appoint this third-party conservator. So it could be a friend, a family member. I was appointed conservator for a young man. He was in his mid-20s, and he had a history of drug abuse. He was in recovery and recovering. However, there was a bit of damage with respect to his memory and ability to kind of handle finances and make appropriate decisions. So because of that, his family thought it would be best for him to have a conservator, and they wanted an attorney to handle that matter. He was competent. He was, able to really fully participate in decision making regarding his finances and property. However, the family felt because of this impairment, because of the long-term use of drugs with in his issues and challenges that he had with that, they felt and he agreed that a conservator would be best so that his finances would be managed properly. If at some point or at any point he felt that he no longer wanted a conservatorship, or he improved and felt that he can handle this or wanted to appoint a different conservator, he certainly would have had the right to go back into court and make those modifications. So the power of attorney is sort of like the first level. Now the conservatorship we're bumping it up sort of to the next level where it's a little bit more formal. There's court involvement, things of that nature. So a guardianship is sort of, I'd say that's level 3 as far as having someone make decisions for you. So what is a guardianship? This is also a court appointed person. You have to actually make application to a court in order to have a guardian appointed. When a guardianship action is commenced, you are telling the court that there is an individual who is incapacitated due to illness or disability, so much so that they are unable to make decisions regarding their own affairs, whether it be medical decisions, financial decisions, any decision. This is something that is not taken lightly by the court, because essentially you are stripping someone of their rights by appointing a guardian. There has been changes in the law over the last couple of years where we always want to try to make it as least restrictive as possible. So a court will look at each specific situation and take testimony or advice from medical professionals when making a determination, because the court always wants to have the individual maintain as many rights as possible, whether it be, the right to participate in some decision making, or the right to vote, or the right to marry. The judges always want the individual to retain as many rights as possible. But if this individual does have issues making proper decisions for themselves, whether it be, personal decisions or medical decisions, that's where the guardian would sort of, take over and make those final decisions. So, there's a question here: when is a guardianship necessary? Well, unfortunately, if you don't have a power of attorney in place and something happens and you become incapacitated, you can't sign a power of attorney once you're incapacitated. So unfortunately, it might be necessary for someone to apply to be your guardian if that was to happen. I am guardian for 5 individuals in the state of New Jersey, different ages, different levels of disability. And so, I am certainly honored to be able to help my wards and my clients with decisions and to try to help them make the best decisions possible for them. But it definitely is a very serious job, and there's many requirements that the court imposes with respect to accounting for their finances. So there's annual different types of reporting obligations. So it is a very serious and very important job as guardian. Let me also say that there's so much to say about all these topics, but we only have a few minutes. So I know that I'm only giving everybody just a taste, just as much information as I can in 20 minutes. And I would hope that if we don't answer your question at the end, then if you needed assistance or you thought you needed assistance with any of these issues, we'll be providing our information. You can certainly call my office and I'll be more than happy to speak with you. I just want to say one other thing before I get into the special needs trust. Actually, you know what? I'm going to move forward. I'm going to address this while I'm done speaking about this. When we talk about people with different abilities, we also talk about, sometimes you'll hear the word special needs trust. The special needs trust is a very specific type of trust. It can't be applied to everyone in every situation. So if you've been told, oh, you have to go get a special needs trust, you really, really need to speak to an attorney about it, because there's only certain situations where this type of trust would apply. So generally, a special needs trust can be created for somebody who is receiving state and federal benefits, such as SSI and Medicaid. The trust has to be drafted and managed properly in accordance with the law. So I would never recommend trying to get some sort of form trust off the internet, because this has to be done in a certain way. Otherwise, anything that you put into the trust would potentially cause you to lose your benefits if the trust was not drafted, and also if it's not managed properly. It's called a first party trust or a self-settled trust because the only funds that can go in it would be the individual's own assets. So I gave the example of proceeds from a personal injury settlement. So let's just say, for example, I was receiving SSI and Medicaid. I had a slip and fall outside of a store in the winter. I hire a lawyer, we get a settlement, and I get a settlement of $100,000. If I was to take that money outright and put that check into my bank account, I am now going to make myself ineligible for SSI and Medicaid. But if I put this money into a special needs trust, then it's technically no longer mine. It becomes trust property, and the trustee has to distribute the money in a way that is allowable under the law. The trust cannot be funded after the individual, the trust cannot be funded after the individual reaches the age of 65. So if I were 70 and it was the same scenario, I would not be able to establish a special needs trust. The trust there are some limitations, but the trust is very, the trustee has flexibility to use the trust monies for the beneficiary's needs. And it would cover education, it would cover uncovered medical expenses, it would take care of any furniture or vacations. You have to document everything and you have to keep receipts, and there's also an accounting requirement every year, but it really does allow to and provides for the beneficiary's needs. The trick with this type of trust is that anything that goes in that trust upon the death of the beneficiary or the disabled individual, all the money left that's in the trust would have to go back to Medicaid. And when I had mentioned an annual reporting, you do have to submit to Medicaid annually. They do review trust distributions. They want to make sure that trustees are not doing anything they shouldn't be doing with the money, that they are actually spending it for the beneficiary's needs. So a third-party trust is similar to a special needs trust. These are also called a supplemental benefits trust. And these are also created to protect a disabled individual's benefits. It's different from a special needs trust because it's funded with the assets from a third party, a parent, family, or friend. And it's often created as part of that parent, family, or friend's estate plan. So what does that mean? If I had a child who is disabled, say that I have an adult child, 23 years old, with disabilities receiving SSI, Medicaid, or other federal and state benefits that are means tested, I would not want to, when I'm creating my will and my estate plan, I don't want to leave any inheritance directly to my child. Why? Because the receipt of that inheritance would potentially make them ineligible for benefits, for their benefits. So if I create in my estate plan this supplemental benefits trust, then when I pass away, my child's inheritance would go into a trust and be managed by a trustee. And that way they would be able to maintain their benefits. So it is very important, not just as a person with disabilities, but also as family members of someone with disabilities, to make sure that any estate plan, whether it's your own or your family's, takes that into consideration. Because if it doesn't, then you have a problem with having to possibly go to court and have that inheritance placed, in a trust. If you can do it at that time, if you can't do it, it's going to put the individual into a very precarious situation depending on the facts and circumstances at that time. So it's very important that we plan for this and that we set a really good plan for those loved ones of ours that have disabilities or special needs. A third-party trust doesn't have an age limit. And the good thing about a third-party trust is, unlike a special needs trust, when the individual does, if there's an inheritance that is still left in the third-party trust, it wouldn't go to Medicaid. You can leave it to other children, other family, or whatever it is that you would prefer. So it's a very specific type of trust, and these are things that we talk about when we are giving counsel and advice to those that want an estate plan. We are running out of time very quickly, so I am going to just speed this up. I have about 2 minutes left. I think I'm almost out of time. And so the last type of strategy for those living with special needs is an ABLE account. An ABLE account is much different than the different types of trusts. It's much more flexible. It acts almost more like a banking account for the individual with special needs. However, there are restrictions. The individual with disabilities must have a documented disability before they turn 26. You can place up to $15,000 annually into an ABLE account. It is tax-free. Anyone can contribute to an ABLE account. In order to maintain eligibilities, you will maintain your eligibility for federal and state benefits like SSI and Medicaid. However, if your ABLE account at some point in the future exceeds $100,000, then there may be, your SSI benefits may be discontinued, but Medicaid would remain intact. You have to have a disability that meets the Social Security Administration's definition of and criteria of disability. A licensed physician has to complete the forms documenting the disability. The disabled individual has the right and to establish their own account, manage their own funds. And this really helps to promote that self-sufficiency because they don't have to go through a trustee if they wanted to access these funds. However, you're restricted because only one person can have an ABLE account. You can't have multiple accounts. And as I had stated earlier, if the ABLE account is established properly, it will not adversely affect the disabled individual's SSI and Medicaid. These are a couple of more benefits of the ABLE account. It's tax-free. It, unfortunately, though, upon the passing of the ABLE account owner, the remaining funds in the account must go to repay Medicaid expenditures. So that's sort of the way around it. It seems like Medicaid and Social Security allowed these special needs trusts and the ABLE accounts because they know they're going to get their money at the end if there's anything left in there. So that's sort of, I think, what they told themselves is, well, we're not going to discontinue your benefits, but if there's anything left in there, you're going to have to repay us. So I am out of time. Again, so much to say in so little time. My phone number is there along with my email address. Please feel free to go to also visit our website where we have so much information. We have videos, we have blogs, we have so much information there. But if there's anything I can do to help anyone, please feel free to give my office a call and I'll be more than happy to speak to you. It was a pleasure talking to all of you this evening. Thank you for having me, and take it away, Ellen.
I have to unmute myself here. Thank you so much, Kim. That was a terrific presentation. And one of the things I just want to mention in following up after the comments that Kim had is that the topics that Kim talked about were obviously always when people are requiring government benefits like SSI and Medicaid and housing vouchers and all those SNAP benefits, it's really essential to go to an expert attorney. And Kim is one of those, and that is just a really critical thing. We don't want to download any documents from the internet and figure that will suffice, because they may be questioned and not honored. And also, as Kim said, some of those documents like special needs trusts are very, they're state specific, and the rules do change. And so you want to go to an expert attorney who really knows the rules, follows the changes. So I think that all of Kim's points were very well taken. What I'd like to do is share my screen now and talk with you about Plan New Jersey. So we are a not-for-profit organization that was established we're about 33 years old now. And we are a not-for-profit that serves people with all different kinds of disabilities. And our mission is to help families answer the question, who will care for my loved one when I'm gone, or the individuals themselves who are worried about how they're going to get support and assistance when family are no longer around to provide that support that some people really rely on. So we actually do serve as trustee of special needs trusts or supplemental benefits trusts. And that critical distinction that Kim made about whether they are a first party or self-settled trust versus a third party trust, they are administered differently. And the critical thing is not every trust is payable back to Medicaid. If you do the proper planning with someone like Kim, or your families do that, you can have your benefits and also have funds to supplement your needs, because certainly it's not a super quality life to live only on SSI, for example, as you know, with the maximum of $2,000 restriction. So the ABLE accounts are a good complement there too. So Plan New Jersey does serve as guardian also, as Kim does. We are actually guardian for about 40 people. When families don't have a successor guardian, then we are able to serve, and some families ask us to do so. We also do a lot of support for families and siblings who serve as guardian or serve as power of attorney. We are able to serve as power of attorney and healthcare proxy, and more people, if they don't have family to serve in this capacity, will ask Plan New Jersey to do so. The individuals themselves, recently we had a man who was hospitalized, and he participates in a program that we call home visit monitoring. It's basically a case management role, an advocacy role. And so we were visiting him, and he wound up in the hospital, and he didn't have any other family to serve as his power of attorney, as his healthcare proxy. So we helped him through that hospital visit and honored the wishes that he had described in his living will. So we serve as representative payee for Social Security benefits when people do need someone to help manage those cash benefits. And a lot of what we do is around the topic of life planning, which is the main focus of what I'm going to talk with you about this evening. But I wanted to mention about this home visit monitoring and advocacy service. So we visit people in their homes, and it's typically once a month. And we're not support coordinators like with Division of Developmental Disabilities. We call it service coordinator, our position, our staff position. And so you have a person who visits and is there to kind of provide some help should you need it. Everybody has cell phones, and the individuals that we visit tend to really become very comfortable with our staff and know that they've got somebody else to support them. And because of our role as trustee and guardian and representative payee, we really have a great deal of expertise in helping people manage and maintain the public benefits. We strongly urge people to work, and you can work and have Medicaid and have SSI, and we urge you and encourage you to do so. And we can help, give you resources to maintain the benefits and your employment. But we know that those benefits are really critical. So, we're here to help people and sometimes families ask us to assist and visit their loved one when they're not able to, if they go on vacation or if a family member is having a surgery or something, and when they're gone, when they pass away. Our staff visit and help an individual with whatever it is they might need, whether it's medical decisions or, staying in touch with friends and family, or working connected to supported employment, whatever it is that the person might need. So I wanted to follow up on Kim's conversation about special needs trusts and supplemental benefits trusts to mention that there is also a vehicle called a pooled special needs trust. So this is very similar to a special needs trust or a supplemental benefits trust, and it is held by a not-for-profit organization. And Plan New Jersey does hold a pooled special needs trust called the Plan New Jersey Community Trust. And this is multiple sub-accounts. Each individual has their own sub-account. It's a bank account. And if there are sufficient resources to invest, then they are invested. And investments can cost a lot of money if you only have a little bit of money to invest. But with our pooled trust, since there are many people participating, it's a lot of money, and then we can invest it for less cost. People can join our community trust at no cost. So sometimes family members will say to us, well, I want to be sure, as Kim mentioned, don't leave money directly to your loved one, because then they could lose their Medicaid, their SSI, and all that money that your hard-earned savings would have to be spent down or put into a Medicaid payback trust, that first party trust. So I wanted to mention this as a resource that you might be interested in knowing about, because it's available and there is no cost to participate. And as Kim mentioned, special trusts, whether they are first party or third party trusts, can purchase many, many things on behalf of individuals. They can buy, Medicaid doesn't give you many physical therapy or occupational therapy sessions, so we can buy more. We can pay for tuition, books, gasoline, clothing, really a variety of things. We can pay rent, we can pay for utilities, but we want to be very careful, as Kim was mentioning about the ABLE account. Sometimes it's better to use a combination of a special needs trust or supplemental benefits trust plus an ABLE account, so that we don't reduce SSI benefits. So that's a whole other area that we can talk about if there's time. But definitely, these are wonderful tools where families can allow, leave some funds to supplement the quality of life of individuals while still on SSI and Medicaid. So the thrust of my talk tonight is the importance of planning for the future. It is so hard and sometimes really frightening. Your parents might comment that they are worried, and it's very hard when you're a parent of a person with a disability to sit down and kind of come to grips with the fact that you're not always going to be there. You may not always be able to support your loved one. So a life plan is a very comprehensive document, and it describes, and you might do it yourself if it's about you, or if it's about your loved one, it might be a parent who's describing who they are, what the resources are, what kinds of available supports do you have, support now, where are those people? If they're called a support coordinator, or if they're called a case manager, where are they connected to, and how do we make sure that we maintain those supports? So we want to write down, resources that relate to living, that relate to home, school, work, and friends, and whatever financial status the person has. Or what you anticipate they will have. And then if there is a power of attorney or healthcare proxy, who that person is, so that support professionals can assist. We can help get those people connected when your family is not around to help. And then It's very important to include who those people are that are going to help you in the future, whether you have a trusted friend, an aunt, a niece, a relative, or organizations like Emotions SIL. We want Motion SIL. We want to make sure that we are knowing the people that know you and can potentially help you. So a life plan identifies key roles. So legal roles, if you have a power of attorney and healthcare proxy, who are those people? So we can contact them. Do you have a supported decision maker? So sometimes people have, they may not have a power of attorney or healthcare proxy. And right now, New Jersey doesn't have a legal role as supported decision maker, but we are working on that. We're looking to promote the autonomy of people if they have someone who can really assist. Many people, most of you, can make all the decisions in your life if you have support, and we all rely on support. Supportive people. If I have a legal question, I'm going to go to an attorney. If I have a financial question, I'm going to go to, a CPA. I don't understand taxes, and I'm not going to try to understand them. So all of us, whether we have, whether we're differently abled or not, we rely on our support professionals. So who are the financial roles? So if there is a trustee, it's important that you know who is that trustee going to be. And many families do appoint Plan New Jersey either as successor trustee. So maybe you have a sibling that is going to serve in that role, or sometimes siblings may not really want to serve and support somebody in the financial aspect of things because it is a very delicate fiduciary role that people need to really be well educated about. Then we want to know who are those people, and we want to write these things down. You may have a TrueLink card. If you're not familiar with TrueLink cards, these are very nice ways of accessing your money. It's a controlled debit card. It's a preloaded debit card. So if you have a trustee, the trustee may be able to give you a TrueLink card to help you access your money. And same thing with an ABLE account. You may be able to have a debit card to access your money. And then home and community supports. Who are the people? Who are your medical professionals? If you are DDD eligible and you go to individualized support planning meetings, if you have an ISP, then you want to be sure that we have that information in your life plan. Who's going to serve in an emergency response? What are things that are important to you from a recreation and enjoyment standpoint? So critical. It's not just the legal and financial stuff, but what do you do for fun, and how do we make sure you get to continue doing that? Who are your friends? Who are your relatives? Who are the people that you want? If you're not able to call on them because you're ill or whatever, then you want this life plan to give that information to individuals. So there's some wonderful new tools. I like visual kinds of tools like this one. This is available on our website, and also at the bottom of this, the website where this directly came from. It's called lifecoursetools.com. And the top box is just describe in just some bullet points, what is your vision for a good life? And then equally important in the bottom box, what is it that you don't want for yourself? I know personally, I never want to be in a long-term care facility if I can help it. And so I want to put that in there and ask that my personal support folks do everything they can to prevent that. And what other things you just don't want for yourself, and this way, the life plan helps your support people achieve what you want and what you don't want. And in the same respect, here's a lovely form that helps remind us the person is in the center. That's that star. You are the star of your own show. And it reminds us that a life plan, we are very broad individuals. So the top left corner is technology. What technology do we need and use to manage our day? I know I use lots of tools on the iPhone. What other things do you use? Do you use a talking device? Do you do a, does your computer read text for you? What are the things, how do you use technology to, enhance your life? The middle is personal strengths and assets. It's so important that we're writing down all those qualities about yourself that help somebody know, because if, let's say, somebody steps into your life and they don't really know you and you're not well, they can't necessarily know. But if we know already, if we know that you are, more about you as a person, we can help get you back to where you were before you became ill. Relationships, who's important in your life? That's the top right corner, and the bottom left corner is community-based supports. Do you go to church? Are you in the choir? Do choir members drive you? Those kinds of things are really important to know. And it's not just any church, but maybe it's the Protestant church or it's the synagogue. What we want to make sure that your preferences are honored, and maybe you've got a good friend in the guy who makes the pizza down the street. We want to be writing those things down to help you maintain the life that you want and also achieve the life you would like to have. And then the bottom right-hand corner, the green section, is about eligibility specific supports. Are you DDD eligible? Do you attend a community mental health center? What services do you receive? Do you have SSI, Medicaid, SNAP benefits, a housing voucher? These things are also, of course, very important. So this can be a really great way to kind of realize the whole person that you are and document these things in your life plan. So we do have a number of frequently asked questions about life plans, about special needs trusts, about ABLE accounts. I'm just going to actually, so let's open it up to questions, though, before we go into this. Let me stop sharing for a few minutes and see if there are questions for Kim or myself.
Awesome. Thank you, Ellen, and thank you, Kim, to start us off tonight. We did have one question towards the beginning. I believe this would be more for Kim. For AMDs, the question, and Helena, jump in if I'm misreading, but how do we fill these kinds of forms out? So also, I guess, who's the best support person, who's the best professional in that sense, in terms of AMDs?
Because the reason why I asked the question is because my dad lives out of state. And he raised me. I guess he's not my real dad, but he's been my guardian when I was in my teenage years. And now he's my Mexican, because my daughter's not old enough to be my Mexican because she's only 13. So if I do it where my dad has to fill out the forms, how can he do that being out of state?
So with a medical directive and a power of attorney, if it's your medical directive or your power of attorney, you would work with a lawyer to prepare the forms. You would sign them before a notary and 2 witnesses. If you wanted to, say, appoint your father as the agent, he does not have to sign. He does not have to sign anything. So whoever it is that wants the power of attorney or wants the medical directive would be responsible for working with a lawyer and signing the forms. Nobody else has to sign those forms.
Okay, so I would just have to sign him and keep him on it until my daughter's 21, right?
Well, what we would suggest for power of attorney and medical directive, we always suggest that people appoint more than one person. We also, you might want to appoint your father and then somebody else, 2 other people probably is what we usually like to suggest. When your daughter then is old enough to make those decisions, you can have those forms revised. at that point in time. And we always do suggest that those forms do be revised every 7 to 10 years because the law changes, situations change. So probably would be a good idea to update it at that point.
Okay, and my other question is, for the third party trust. For me, I receive all the things that you were saying, like the Social Security income, Medicaid. I also get Medicare and food stamps. So my dad was talking to me a couple years ago about he wants to, when he has me in his will, but because I receive SSI, he took me out of it because I wouldn't be able to receive the money. But now that I know that there's a third party trust that we can do, how would I be able to like have him contact somebody? He would have to contact somebody there in Rockford, right?
Yeah, he would have to speak with a estate planning or elder law attorney, so someone that does what I do in the state where he lives, because laws might be different. So he really needs to speak to a professional in the state where he lives about, you know, his estate plan and you know, planning for you in his estate plan. He would have to see a lawyer in that state.
Okay.
Thank you.
Awesome. Thanks so much, Kim. Another question we received in the chat is, my husband is discussing with my disabled adult son about giving him some of his disability monies to invest. Is this a good idea, or can this backfire and help him lose federal estate benefits? Currently, he gets SSDI and SS retirement along with Medicare and Medicaid.
So I'm going to jump in and say, I don't necessarily feel, and please forgive me, I have to be careful about giving, you know, today's presentation is really to provide general information. It's really hard for me to give specific legal advice without getting more information. So for Barb, you know, if you want more information on this, I would certainly encourage you to contact my office and maybe schedule a consultation with me, because you know, we're using words like invest and this and that. I really need more information before I can make a determination as far as what your husband plans to do and how that could affect your son. Because it seems to me like you have two people who are on disability, your son and your husband. And so we certainly wouldn't want either of them to have any negative impact on their benefits by this plan. So I would be more than happy to talk to you in more detail about that.
Can I just ask, can you mute yours, please? So my husband should definitely not give him money within the next week so that he can buy some Bitcoin without talking to you, right?
Again, I don't know the specifics of the situation. I'm not clear regarding who's receiving what or how it's going to adversely affect the benefits. So I don't feel comfortable rendering any legal advice to you on your question, unfortunately. So if your family wants to wait and speak with me first, I'd be happy to do that. But it's just too specific of a situation. I just don't feel comfortable rendering advice.
Thank you.
All right, Kim. So I guess for the second question too, that would also be specific advice. But I guess in general, does the person who the ABLE account is for have to agree to it? I guess is a more general way of putting that.
Well, for one thing, depending on what, whether the person has a legal guardian, if the person has a legal guardian or a conservator, then that guardian or conservator has the right to open an ABLE account, and also a representative payee can open an ABLE account. It isn't necessary. It is possible for someone else to make that decision. However, the funds in the ABLE account belong to the individual, and that person has access to those funds. They have complete authority to use them, spend them, because the money belongs to them. Kim, is there anything you would add to that?
I agree. It just, if the person with disabilities is objecting for some reason to the creation of the ABLE account, this to me is something that's a benefit to somebody that they would want to participate in and understand its benefits. Sometimes it's just a matter of getting more information, but I wouldn't force somebody to open an ABLE account if it's not something that they wanted to do. And I do agree with Ellen, if somebody else has decision-making power, then that person might be able to do it. But if not, then I don't necessarily know if I would try to, force someone's hands in creating an ABLE account if they didn't want one.
Thanks, Kim and Ellen. Ellen, one more question for you. You brought up using a combination of a special needs trust or ABLE account to kind of navigate through those contingencies. Does that make the process more complicated rather than just doing one or the other?
Not necessarily. It's certainly the administration of either of these. They have some challenges, especially the management of a special needs trust. But as you would, again, I am not an attorney. I do not give legal advice. But as trustees of special needs trusts, we administer them, and so one of the things you have to be aware of, you might be aware that with SSI, if somebody else pays your rent, and same with Medicaid too, actually, if somebody else pays your rent, then that's going to be considered income or in-kind support and maintenance in the SSI world. And then your cash benefit, your monthly cash benefit, can be reduced by $261 a month. So what we do in some cases as trustees of special needs trusts, if someone needs help with their rent and they have enough money in their trust or supplemental benefits trust, one or the other, we will put money from the special needs trust into the ABLE account, and then the person has to pay their rent from the ABLE account. When it's done in this manner, that SSI reduction doesn't take place. So that's one of the benefits of an ABLE account is if your rent is paid from the ABLE account as opposed to out of the special needs trust, your SSI does not get reduced. You'll get your full. So the average SSI is around $800 a month. And so if I pay the money directly out of a special needs trust, it's going to get reduced to, around $550 a month. So it's a little complicated. All of these things are, the programs are complicated, but there's a real benefit to using both. And that, as I mentioned, is the reason to avoid that reduction in SSI cash benefit.
Thank you so much, Ellen. I know that we are running a bit later. Are we good for 2 more questions that popped into the chat? Awesome. So we've got, does a power of attorney cost money? So I guess appointing one, why would a person choose a special needs trust over a third-party trust?
So we do charge for a power of attorney. I think our prices are very reasonable. I'd be more than happy to discuss pricing with someone, if someone has a specific interest. I have also done payment plans. We're really flexible. So if you really want a power of attorney done professionally by my office, I'm more than happy to discuss that with you and we can work something out. Having said that, you wouldn't, so deciding whether or not a special needs trust or a third-party supplemental benefits trust is appropriate isn't really a choice. It's dictated by the situation. So like I had said earlier, a special needs trust, it has to be funded with the individual's own money. A third-party trust is, you have another person that is creating this trust with their money for the disabled individual. So we would recommend one over the other depending on what your specific situation is. Unfortunately, you don't get to pick and choose. The facts are what dictate which one is most appropriate for you.
Great, thanks, Kim. And so everyone, Kim did put her contact information into the chat because it went off from her slide. So if you scroll up a bit, it will be there, or you can shoot me an email and I can get that over to you. So the last question we've got is, how much can a parent give to a disabled son or child before SSDI and benefits from Social Security or Medicare is affected?
Ellen, I don't know if there's anything you want to say on this, but I'm going to, again, simply say, to me, this is bordering again on legal advice. I don't know who's giving the money, who's receiving the money, what is the goal here, how much are you giving? And, Social Security and Medicaid have very, very specific rules. And, violating those rules or doing something you're not supposed to be doing puts your benefits in jeopardy. So I don't, without having more information, I really don't feel comfortable answering that question.
Yeah, I think that the most important thing to realize here is that, yes, attorneys charge money, and and this advice doesn't necessarily come free, but it is so well worth getting it, because the value of those of that advice and the value of the benefits really make it worth your while. And I think it's wonderful that Kim will work with you on price. But these are really, as you know, we want to preserve these benefits. There's ways that you can, work to reduce costs. For example, our pooled trust does not cost any money to join. And so that's, one way. Sometimes families, they think they may not have anything to leave to their child, but they hope that they have a small amount so they can, leave it, we don't open the account, we just sign what's called a joinder agreement, the person does. But again, we don't do this without the person consulting with an attorney, because it's very complicated, and you want to do the right thing by your child. And we want you to do the right thing by your child. So we, in the role of a trustee or even as an advocate, in a case management role, we always work together with our partners, our attorney partners, in making sure that the work, whatever is being done, is really to your best benefit. So as we mentioned, I'd like to, end with a little bit of a story. We had one person who whose parents had done all the proper legal work, and they had the proper will, they had a proper trust. It was a third-party trust because it was their money going into it, and so Medicaid everything had been done properly by an expert attorney. And they asked us to stay in touch with this person on a regular basis and oversee his needs. And in this case, it was a legal guardianship. They asked us to become successor guardian. And the challenge was that he was only 21 years old. Sadly, dad had passed away, and mom got a cancer diagnosis real quickly, and passed away very quickly. We didn't have a life plan for him. So at 21 years old, we became this man's guardian and knew nothing about him. We had all the legal papers in place, but we didn't know that he and his family had desired all his life to go to a special college program that was very expensive. But luckily, he had an elderly grandmother that was able to clue us in. We became his trustee, and learning from his grandmother, they had saved all their life so he could go to this college program. So then we knew as trustee, oh, absolutely, we're going to pay for this, because this was the priority of the family. We knew that he wanted to work more than anything else. And so we were going to make sure that we were managing his benefits in such a way and calling in experts that could help, like New Jersey Wins. I don't know if you're familiar with it, the Work Incentive Network Support. I can send you the website for that. They will help you manage your benefits and go to work. So it's just, this is kind of, I just want to drive home the importance of write your own life plan. You know, write out what is important to you, what you want for others. You know, I think I mentioned that we had a man who was very ill who asked our service coordinator, the staff member who was visiting him, he's in the hospital, and he asks us to serve as his healthcare proxy. And we can do that. Our bylaws allow that. And, you know, we agreed to it, but we were very nervous that he stayed well enough to communicate to us what he wanted. You know, did he want life-sustaining measures? Did he want a feeding tube if asked? You know, those were the kinds of things. So please do, you know, think about writing down what's important to you, what you want, you know, if you're ill, and share that with people that you trust that are in your life. And certainly if you want to talk more about life planning or the role of Plan New Jersey as trustee or as a support person in the role of home visit monitoring, we're happy to talk with you about that. So you can feel free to call me directly. And I'm going to, I saw in the chat, somebody wants the New Jersey Wins resource. So what I'll do is I'll send it to Emily and she'll pass it on to you guys. Thank you so much for your attention and your great questions. We really appreciate it.
Yes, thank you so much.
Thanks so much, Ellen. Ellen, if you could just pop your contact info into the chat itself, that'd be super helpful for those who are on. I will do the same actually. And then anyone who does need some additional info, please direct message the motion SIL on this chat and just give me your email that I can reach out to you.
And thank you so much for doing this. I learned a lot tonight, so thank you.
Oh, good. I'm so
Thank you
glad.
so much, Ellen and Kim. It was, again, hearing a lot about Britney Spears and conservatorships, there's a lot more to it than what the media portrayed and just kind of like the big, you know, the big details of it. So thank you.
You're welcome. Thank you.